All right, so why don't we go ahead and get started with our webinar. Good afternoon, my name is Paul DeBolt. I'm the chair of Venable's Government Contracts Group. We're going to welcome you to the third and fourth installments of our four-part bid protest series. Our first topic today relates to key personnel, and joining me for this discussion is Taylor Hillman. So Taylor, why don't you take a moment to introduce yourself?
Hi, everyone. Thanks for joining us today. My name is Taylor Hillman, and I am an associate in the Government Contracts Group at Venable. I've been at Venable for a couple of years now, and my practice consists mainly of bid protests and corporate transactions.
All right, so let's go ahead and talk a little bit about personnel issues. I have to say, Taylor and I do a lot of bid protests, and over the last 24 to 36 months, we've seen a lot more of these issues arise in the context of a protest, either with the awardee's proposal or issues with a disappointed offeror's proposal. Typically, these are going to arise in one or two scenarios. A lot of times, if you're the awardee, the disappointed offeror is going to be looking at your current employment openings on your website to see if there's a key position that might appear to be unfilled. The other way this arises is in the context of the actual protest, where once outside counsel receives the agency report, which will include your technical proposal, your cost proposal, if the key personnel are not redacted, they will look to see if these individuals are still working for your company or not. We kind of joke around about this and call it sort of the LinkedIn protest round, because a lot of times when these protests get raised in the context of a supplemental protest, it's because of something that somebody found on LinkedIn to show that a particular key personnel was no longer working for the company. I mean, sometimes this arises because of loose talk on your team that somebody is left. But by and large, it's based on internet searches. This ground also sort of underscores why it's important, if you're an awardee, to get outside counsel involved in the intervention, because one of the things that outside counsel can do for you is to attempt to narrow the scope of the agency report or ghostwrite motions to dismiss that the agency may use to try to eliminate these grounds. So why are key personnel protests so challenging? Well, the reason they're challenging is that they can eliminate your company from the competition. And this is one of those rare opportunities that a company can snatch defeat from the jaws of victory. The GAO looks at these very closely. And as many of you know, as experienced government contractors, the presence of a protest can impact morale, can impact whether somebody wants to stay with the company or not, or take another job. So it's very important that with regard to key personnel issues that you stay in front of those. So to kind of guide our discussion, Taylor and I put together pulled just some typical language for key personnel from a request for proposal. As all you know, the instructions for how to put your proposal together are set forth in Section L, and then how the government is going to evaluate the criteria set forth in Section L. And as you can see in paragraph B, it requests offers to provide resumes for all proposed key personnel. It lists what the resume must include, and it also requires a commitment letter with the signatures of key personnel saying that they are going to perform in the stated position at the time of contract award. And then Section M talks about how this issue is going to be evaluated. Now, a lot of the key personnel requirements they're pretty standard across the various RFPs that we see. Typically they request resumes either with an individual's name or just an exemplar of the type of person you will hire. And frequently, or almost always, for key personnel, they want a letter of commitment or letter of intent. what the education component is fairly straightforward. They want to know whether they'll state whether the person needs to have a bachelor's or a master in a certain area, or is there some experience requirement. The experience can include specific experience with a particular agency, with a program, or a project similar to the procurement at issue. Frequently, you're going to see a certification requirement where they'll state a specific one, professional management, professional ITIL foundation, or some sort of equivalent. Letters of commitment, that's straightforward. We've talked about that, like what it says, and that it evidences an intent for the person to be a part of the program. Now, it's important to read the requirements concerning both resumes and letters of commitment very carefully, because when those are required by a solicitation, these documents are a material requirement. So if you don't have it, your bid is going to be non-responsive. Therefore, any even a minor deviation or failure to include a piece of information could amount to a deficiency. So you need to be very careful. And we'll talk about this in a little more detail when we talk about best practices. Now, with regard to these criteria, this is a great place for potential offerers to avail themselves of the Q&A process. And what this enables you to do is to clarify the qualifications, ask whether some alternative experience would be permissible. Are there other certifications that the government may find acceptable? And, will greater weight be given to somebody that's an incumbent on the existing contract? Because this can be a problem at times, because Taylor and I have both seen cases where an incumbent has bid for a new procurement. It's a continuation of existing procurement, and they propose the incumbent personnel because they believe that the agency likes the work that they're doing, wants to have them win the contract, and they don't go and check to see if the incumbent personnel actually meet the key personnel requirements or meet the qualification requirements. So you can't have a situation where you are the incumbent and you have personnel working for you that the agency is very fond of, but you may not get the award the second time because that individual does not meet the qualifications that were set forth in Section L, the criteria that was required to be submitted in Section L and then evaluated under Section M. So what happens if a key personnel resigns? Well, it could be very detrimental to your chances of receiving or maintaining an award. It's a material requirement, and the unavailability of a key person can render your proposal unacceptable and unawardable. The other thing that arises is, if you fail to provide the resumes or required letters of commitment, it can also render a proposal technically unacceptable. So, there are a couple cases there that highlight this point, that it is that they are material requirements that you need to adhere to. The other thing that we see pretty frequently in this context is an allegation of a bait and switch. And this is essentially an intentional misrepresentation about the availability of a proposed person to perform under a specific contract. And in order for a protester to establish an impermissible bait and switch, they're going to have to show that the awardee either knowingly or negligently represented that it would rely on a specific person that it did not have a reasonable basis to expect to furnish during contract performance, that the misrepresentation was relied on by the agency, that is, that they relied on the presence of this individual or this individual's performance on the contract as part of the evaluation, and that the agency's reliance on the misrepresentation had a material effect on the evaluation results. So what's the takeaway from that? It's important to propose individuals for performance that you have reasonable assurances are going to be able to perform the contract to avoid this allegation. So Taylor, with that, why don't you go ahead and walk us through some of the cases that sort of highlight some of the things that we've been discussing.
Sure, thanks, Paul. Next, we will overview a few of the key GAO decisions discussing offerors' obligations when it comes to the departure of key personnel, as well as the possible repercussions of a departure prior to the time of award. First up, we have Paradigm Technologies. In this case, one of the awardee, Booz Allen's key persons, its program manager, became unavailable after the time for the submission of proposals, but prior to the time of award, where that individual became employed by another firm. Paradigm protested, alleging that Booz Allen knew of the PM's unavailability as soon as they were aware that she had accepted a position at another firm. The agency took corrective action in response to that protest, but ended up re-awarding to Booz Allen following reevaluation, only assigning Booz Allen a weakness for failing to provide one of the key personnel. Paradigm again protested, and this time the GAO agreed, explaining that key personnel requirements are material and that a simple reevaluation of the Booz Allen proposal without allowing proposal revisions should have rendered Booz Allen unacceptable. The key takeaway from this case is that an offeror has an obligation to inform a procuring agency of changes in its proposed staffing and resources, even after the submission of proposals. Departures after the time of award typically will be considered an issue of contract administration that cannot be protested at the GAO, but up until the time of award, it is important to notify the agency should changes occur. Next up, we have URS Federal Services. The GAO highlighted its paradigm holding in this matter. One of URS's key persons departed from URS after the submission of proposals, but before award. As a result, the agency eliminated URS from the competition, finding URS's proposal technically unacceptable for failure to meet material key personnel requirements. URS protested its elimination, arguing that the agency's assignment of an unacceptable rating to its proposal was unreasonable because the departure of the proposed key person was not URS's fault. The GAO acknowledged that the key person's departure was not the fault of URS, but nonetheless found that the agency acted reasonably, both in deeming URS unacceptable and eliminating URS from the competition. The key takeaway from this case is that where key personnel requirements are material, agencies essentially have two options when a proposed key personnel is revealed to be unavailable. First, they can either evaluate the proposal as submitted and reject it as technically unacceptable for failure to meet material requirements, or reopen discussions allowing the offeror to correct the deficiency through proposal revisions. If a protest challenging the availability of a key person is raised and found to have merit, or if the agency discovers on its own accord that a proposed key person has departed, it's within the agency's discretion to allow for proposal revisions or simply find that offeror unacceptable, further highlighting the importance of ensuring key personnel are available at least through the time of award, if not the beginning of performance.
Yeah, I mean, and this really puts an offeror in a difficult position because, you know, if a contract, and this happens a lot, where a contract gets protested, there may be some perceived merit to it, the agency takes corrective action, and then the award date continues to get pushed to the right. And during the corrective action period, people get nervous, they start to look for jobs, better job opportunities arise. And then you're in the position under the GAO cases of having to raise your hand about this departure. And there's no guarantee that you're going to get another opportunity to get an opportunity to substitute out that key personnel. I mean, you could just get evaluated as if that person doesn't, you know, to reflect that person's no longer available. So, I mean, it really is a very difficult situation that the rules put people in. So it really is important to maintain those relationships with the key personnel. It's important to communicate about what's going on. And I think that's another place where outside counsel can help you, because they can help you shape the corrective action. They can get some sense as to how quickly the corrective action is going to occur, so that, you know, there's information available that you can use to manage your workforce. So Taylor, why don't we talk about AT solutions?
Sure. Next up, we have AT Solutions. In this matter, the GAO doubled down on its principle of agency discretion. It denied the protest brought by AT Solutions, alleging that the Navy unreasonably declined to reopen discussions, where after the submission of final proposal revisions, the protesters' proposal became technically unacceptable because one of its key personnel departed. Specifically, after 2 rounds of discussions had closed, one of AT Solutions' proposed key personnel departed the company. AT Solutions promptly notified the agency of this unavailability, and in response, the agency disqualified AT Solutions as unacceptable. AT Solutions protested, arguing that the agency should have reopened discussions to allow it to substitute another individual for the unavailable person, but the GAO denied the protest, despite the fact that the elimination of the incumbent left only 2 offerors in the competition. And the key takeaway from this case is that even if an offeror is extremely proactive in telling the agency about the departure of a key employee, the agency still, in the end, has the discretion to remove that offeror from the competition without allowing proposal revisions.
And so, I mean, it's really important in this context that as you're thinking through how you're going to handle these issues, that you do need to evaluate your relationship with the agency to determine, whether it's more likely than not they would give you an opportunity to make proposal revisions. But, as you can see from this case, it's discretionary. And given the level of deference that the GAO shows the agency, it would probably be extremely rare, if ever, situation where they would sustain a protest objecting to that decision.
Next up, we have MC Dean, which was a pretty significant GAO decision. Therein, the GAO established an actual knowledge standard governing when offerors must advise a procuring agency of a proposed key person's departure. MC Dean protested, alleging that the awardee had improperly failed to notify the agency about the unavailability of one of its key personnel. Specifically, 2 months after proposal submissions, the awardee's program manager was denied the required personnel security clearance under the contract. And while the awardee was under the impression that that employee planned to appeal the denial, he ultimately did not. The GAO concluded that as soon as an offeror has actual knowledge that its proposed key personnel will not be available to perform, it's obligated to inform that agency. In this case, the GAO found that the awardee had actual knowledge of unavailability, but failed to notify the agency of this development. The GAO made a point to emphasize that even though the program manager had a right to appeal the denial of the security clearance, this did not affect the awardee's obligation to notify the agency, indicating that as soon as a key personnel is found to be unavailable, even if that may change in the future, the disclosure obligation is triggered.
Yeah, I think that's an interesting point, in that even though the manager had an opportunity to have that decision overturned, that as soon as the first disqualification occurred, that triggered the notice requirement, not until the whole adjudicative process was done. I don't know, I think this is also one of those cases that sort of underscores with regard to key personnel that sometimes ignorance is bliss.
Lastly, we have TMPC. In this matter, the GAO denied protester TMPC's challenge to the assignment of an unacceptable rating to its key personnel proposal for its failure to satisfy relevant experience and education requirements, which we discussed earlier. One of TMPC's proposed key persons did not possess the requisite qualifications or years of experience, and the agency assigned an unacceptable rating pursuant to the terms of that solicitation. The GAO agreed with the agency's position that it was not evident from the face of materials submitted that the individual proposed met the qualifications, and that finding the proposal compliant would have run contrary to the solicitation. The GAO also highlighted offeror's responsibility to submit a clear and well-written proposal. Specifically, it is vital for offerors to submit clear proposals that align with the requirements of the given solicitation, especially when it comes to overviewing the qualifications of key personnel, specifically within resumes. And as a matter of best practice, resumes should be easy to follow and directly address all qualifications and requirements specified for that given key position. The key takeaway from this case being the agencies are not required to read between the lines or search through an offeror's proposal to find that a proposed key person meets solicitation requirements when the offeror has failed to state such information plainly or adequately.
Yeah, I mean, I think that this kind of underscores the whole idea in the context of proposal writing that neatness counts. And, there's obligation to submit a well-written proposal. And part of that is clearly articulating the requirement, clearly articulating why a specific individual meets the terms of the contract with regard to their capabilities and ability to perform. So I think with that, we did have one question come in that I honestly don't know the answer to, but I'll read it. It's the question was, does the company have any recourse on the former employee that signed the letter of intent to support the contract and award, but left the company prior to award? I don't know. Candidly, I don't know the answer to that. I don't know if any of the other panelists do, but I'll certainly go to our employment folks and see what rights a contractor may have. I can't think of a single instance where any of our clients have gone after a key personnel that had left, but I can't say that it's never occurred. It's just not something that I've seen, and I would think that, I don't know. I mean, Virginia is pretty pro-business, but I just don't know. But we'll track that down and get back to you. So we're going to wrap up this first part of our presentation with some best practices that we think you ought to consider in trying to address this issue, given how often it arises. One of the things that you want if you have a letter of intent, you want to make sure it's submitted. You want to make sure that it identifies the position they're going to work in, and make sure that it gets tied to the contract. I mean, sometimes there can be a problem, as Taylor and I were discussing, that the letter of intent is not specific enough.
And the issue could be as small as including the wrong font size, or the individual didn't affix his signature and a signature is required. Something that minuscule could be the difference between being acceptable and unacceptable.
The other thing that, you could consider, and I recognize that companies don't have unlimited funds and you can't afford to keep a marching army, but to the extent that a matters protest, that you may want to consider offering some sort of retention benefits or trying to find other work for them within the company so that they're more willing to stay. I mean, it's very difficult for people to sit for 100, 160, 180 days and just build an admin. It's not very rewarding. People get bored and they're going to start to look for other opportunities. The other thing that we've seen that's been beneficial, one of the things I mentioned early on was that typically your competitors will go to your job site and see whether you have any positions that are key positions on a particular pursuit, and then make the allegation that, well, you must not have the key personnel because these job requisitions are still open on your website. And we've been able to address that issue with a couple companies because their human resources department has an actual procedure or policies that they keep jobs posted, until the contract is actually awarded, and even at some point after that. So it was really easy to address that issue, when you have a policy or a procedure in place that, well, this is how we do it. It doesn't actually mean anything.
Right. Typically, this practice can be cited as rebuttal evidence to a protest ground challenging the availability of key personnel based on these job postings. If it's able to be proved that this is common practice, that the company keeps a pipeline of qualified candidates at all times.
The other mistake that Taylor and I have seen is that sometimes people try too hard a lot of times a solicitation will only require you to identify 2 or 3 key personnel, but then somebody gets the idea that the more is better, and they identify 7 key personnel, and then one of the non-mandatory key personnel leave, and then all of a sudden you got a problem. So, you know, be careful how you write things up. And I know people want to exceed the requirements, but when you're looking at the requirements you're trying to exceed in the drafting your proposal, you might want to pick and choose about the ones that are really unnecessary that could come back to bite you at some point.
Right. As soon as an offeror proposes an additional key person, that person is considered key. So they will be judged under the same criteria as those required under the solicitation.
The next one, you know, it's really important to make sure that people have the qualifications and experience as the date of the proposal, including clearances, training certifications. I mean, where this can get tricky is if people feel that a specific certificate or something has the same effect as the one that was required, they'll just propose the alternate qualification or alternate certificate. The thing is that if you haven't clarified that through the Q&A process, you know, the government doesn't have to accept it. You know, key personnel resumes, all important. The other thing that's really important is the timing for the experience. I mean, we've seen situations, and you know, Taylor and I were talking about this before we got started today, where let's say you have an individual, let's say the requirement was 5 years experience in a particular area, and the person actually only has 4 years chronologically. But what a company will sometimes do is if the individual was a 0.5 FTE on one contract in year 3 and a 0.5 FTE on another contract in the same period for the entire year, they'll try to count that as 2 years, and that's just not going to make it.
Right. Or if a position ends, let's say in February, and the next one begins in February, you typically won't receive credit for 2 months of work when they end in the same month.
I mean, the other thing I think that, you know, we kind of emphasized earlier and that we'll wrap up with is that it's just communication is key. That if you let people sort of speculate about what's going on, if things are unknown, that's when people get nervous and that's when people worry about their livelihood. So I do think it's very important to continually communicate with your team about the status of the protest, you know, potential likelihood of success and things like that. I mean, and certainly if you're the awardee, you know, the GAO only sustains about 14 or 15% of all protests. So you have
They're saying they lost your audio.
What's that?
Well, in sum, the best possible course of action is to relieve the doubts of both your employees and the procuring agency to the extent possible. It looks like we do have one more question, Paul, before we switch to part 4.
Yeah, so this is a question from the audience that a company had recently received a debrief that indicated that an offer's proposed KP met the requirements on paper, but they knew the individual and knew he would not be a good fit, and therefore rated the KP unacceptable in scoring. And then the question is, isn't this a violation of the FAR and protestable? I mean, I have to know more facts, but if the individual actually met the KP requirements, like, I'm not sure how they would then conclude that the individual wasn't acceptable. It sounds like this was more personality driven rather than driven by the terms of the solicitation. You know, you could potentially raise that in a protest. I mean, it could be argued to show some bias or something like that. But again, anytime you do file a protest, the GAO is so deferential to the agency's discretion. And if they had documented the reasoning clearly in their evaluation, if it seems reasonable under the circumstances in the context of the evaluation, that would be a tough one to prevail on. And even if you did prevail on, there's no chance you're actually going to get the contract. They could just go back and paper the record better and show, even if you got credit for that the other offer's proposal was more highly rated or, provided a better value to the government. Oh, Taylor, what do you think?
Building off of what Paul was saying, I think we would need to see more documentation, whether that's a brief explanation or your unsuccessful offer or letter, to see the reasoning given for that finding. But if that were actually the basis for finding the key person didn't meet those requirements, that would be a failure to adhere to the terms of the solicitation and an unreasonable evaluation. So if the allegations are meritorious, yes, that is a protestable issue.
All right, well, thank you, Taylor. That was interesting. We're now going to move to our final installment in our bid protest series, and this deals with organizational conflicts of interest. Here is the overview of the presentation, but before we get started, I would ask Lindsay and Chris just to introduce themselves.
Hello, everyone. This is Chris Breezidick. I'm an associate in Venables government contract. Oh.
Chris, go ahead.
Can you hear me now?
Yes.
Okay, great. This is Chris Breezidick. I'm an associate in Venables government contracts practice. I joined, in December of 2016. And I do a lot of bid protests as well as claims and advising clients in other various matters as well.
Hi, everyone. My name is Lindsay Reed. I'm also an associate here in the government contracts practice at Venable.
All right. So, Chris, you have the overview slide up, but I thought, why don't you just go ahead and provide us with the summary of the various OCIs that arise in the context of a government contract?
Sure. So there are basically three kinds of OCIs that we're going to go through. One is biased ground rules, another is impaired objectivity, and one is unequal access to information. And that last one, there are a couple different variants. Before we get into that, we have a slide here with some general principles on OCIs. Most of the rules on OCIs derive ultimately from FAR section subpart 9.5. And pursuant to that section, the government's obligation is to use its common sense, good judgment, and sound discretion, both to identify whether there's a significant potential conflict, and if there is, then to resolve it appropriately. And there's sort of two guiding principles there. One is to avoid conflicting roles that could bias a contractor's judgment when performing for the government. And two is preventing an unfair competitive advantage. And that latter term, in most situations, revolves around what information did people have in their possession during the competition to receive an award. And really, there are two kinds of information you can see here that are usually at issue. One is proprietary information, so that could be a competitor's labor rates or their technical solution, which contractors should not have during the competition. And the other is source selection information. So that's oftentimes information that doesn't come directly from someone's proposal, but which the government often has in its possession. That would also be unfair for just one person to have during the competition. A good example of that is if there's an independent government cost estimate. Obviously, it would be unfair if just one offerer had a copy of that and the other offerers did not. Next slide, please. So starting off with biased ground rules. This kind of OCI typically arises where a firm that is performing one government contract has in some sense set the ground rules for the competition of another government contract. And the most common example of this is if you are performing a contract for the government, and as part of that performance, you draft the statement of work for a separate contract, or if you draft materials that could go into a statement of work for another contract. If you do that, you shouldn't compete on that other contract. The idea being that when you wrote the statement of work, you could have written it in such a way that you would skew the competition toward yourself, whether intentionally or not. So think of an example where a contractor is drafting a statement of work for the government, and they're able to write a requirement in such a way that that contractor is able to meet it easily, but it would be difficult for other competitors to do so. That is the sort of issue that arises with biased ground rules conflicts. There are also specific rules in the FAR for systems engineering and technical direction at FAR 9.505-1. It's a little bit beyond what we're going to get into today, but I just included the site there in this slide for people. If we can move to the next slide, please. So here, sometimes it's easiest to define what something is by also looking at what is not that. So these are situations which do not create a biased ground rules OCI according to the GAO. So for example, if you just have a prior or current contractual relationship with the contracting agency, that alone does not give you a biased ground rules OCI. There would have to be some sort of unfair advantage that was created by an improper preference or unfair action by the agency on your behalf stemming from that relationship. In addition, let's say you have a contract and you're really not drafting the statement of work or materials that are going to be a part of it, but you are providing some sort of recommendations to the government about future conduct, and some of those recommendations might be generally relevant to a future procurement. Those sort of general improvement recommendations, which are non-specific and are generic, the GAO really is very unlikely to find those to create a biased ground rules OCI. Similarly, let's say you have a situation where you're helping the government with planning, but you're not doing direct acquisition support. So I have a case on bullet 3 of this slide here, superlative technologies, where the awardee was providing planning necessary to build cyber invent environments around customer requirements, but they weren't actually providing real acquisition support. Again, the GAO said that that's not a biased ground rules OCI. And then finally, the FAR again has some more specific exceptions in it for sole sources, design and development work, and if more than one contractor was involved in preparing the statement of work. So the big broad concept to take away is really in those two middle bullets, the idea that if the work you're doing for the government is broad and general and high level enough, then even if some of your recommendations are going to be tangentially related to a future acquisition or even appear in that PWS or that SOW, it's not necessarily going to create a biased ground rules OCI. Keep in mind, though, and we'll discuss this more, OCIs are very fact intensive, and so even small facts could change the outcome. Next slide, please. So next, we're going to talk about impaired objectivity OCIs. These OCIs arise where a firm's ability to give impartial advice to the government during performance would be undermined by some interests that firm has. And the real concern here is that the firm has a relationship to the product or the service that it is evaluating, such that it really can't do that evaluation in an impartial way. And the big concern, you can see this in the last bullet, is that if you're evaluating your own products or your own services or those of a competitor, there's a fear that the advice you're providing to the government is not going to be impartial at that point. And so you have your objectivity in providing that advice has been prepared. Note, though, that the GAO has said, and this is in the third bullet from the Trident case, that, and this comes from case law at the Court of Federal Claims and the Federal Circuit as well, the GAO is going to be looking to see whether there is a direct financial benefit to the firm alleged to have one of these OCIs. So if the sort of if the way in which you might be able to direct work to yourself by evaluating your own product or service is very, again, tangential and difficult to see how there could be any possible financial benefit other than a very indirect one, there may not be an impaired objectivity OCI after all. Next slide, please. So again, running through situations that do not create this kind of OCI. If you're making recommendations on a product or service and you don't have a sufficient level of discretion or decision-making authority, and all the decisions ultimately will reside with the government, that can mean that there is not an impaired objectivity OCI. And I think I mentioned this on a later slide that we'll get to, but just keep in mind that leaving decision-making authority ultimately in the government's hands on its own is not going to be enough. It's important that there's also not really a level of discretion left to the contractor in the first instance. And that sort of gets at the third bullet on this slide from the Dava and Associates case, where the GAO said that the contractor's responsibilities were not based on subjective judgments or evaluations, and so it really couldn't create an impaired objectivity OCI. So that has to do with the level of discretion, right? If you're engaged in activities such as just monitoring whether or not someone is staying on schedule and it's binary, it's objective, and there's really no place for any subjective judgments to be injected into the process, then you really don't have the level of discretion or decision-making authority for there to be an impaired objectivity OCI. And then finally, that middle bullet gets back to the point I was making in the last slide, which is that if the contractor's recommendations about a product or a service are based on high-level data and it's really not able to drive work towards the contractor, you're not going to have an impaired objectivity OCI either. Next slide, please. So now we're going to talk about unequal access to information OCIs and unfair competitive advantage, which is a term of art at the GAO that we'll get to in a moment. So unequal access to information happens where a company has access to information that is non-public and is competitively useful from their performance of one contract, and it would give them a leg up in an unfair way in a competition for another government contract. The concern here is really just exactly what we discussed earlier, that you have either proprietary or source selection information that would assist you in getting that new contract that other people in the competition don't have available to them. Next slide, please. So some situations where there is not an unequal access to information OCI. The mere fact that you're an incumbent contractor, and this one comes up a lot, and you have prior experience under a government contract with the agency that you're now submitting an offer for their solicitation. Absent some evidence of preferential treatment or other improper action, the mere fact that you're the incumbent and that gives you certain inherent advantages does not mean you have unequal access to information. People oftentimes make the allegation that the incumbent had an unequal access to information OCI, but when you look at it, all they're saying is this person was the incumbent and therefore they're very familiar with the government's requirements. Being familiar with what the government wants and likes is not in itself an OCI. This has to be non-public information that is competitively useful in an unfair way. And so the GAO has said that just being an incumbent and being familiar with the agency and what it likes is not unfair. Another example is if the government has data that would give someone an advantage in the competition and it would be unfair for just one person to have it, the government can provide that to all the offerors and effectively eliminate the OCI concern. Now, you can see a situation where the government doesn't give that data up in time or it doesn't provide enough of the data for it to be useful for everyone in the same way it is for the incumbent, let's say. But nonetheless, the general principle is that the agency can provide data to all offerors and eliminate an unequal access OCI that way by providing equal access. Similarly, if the protester complains that the awardee had access to information, but the protester also had access to that information, the protester can't complain at the GAO. They can't demonstrate that they were prejudiced because they had the same information themselves. Finally, if information is stale, such that it's no longer competitively useful, then it's not going to be something that creates an unequal access OCI. And this makes sense, you know, like if somebody got access to an independent government cost estimate, but it's from a procurement from 15 years ago and the requirements have substantially changed since then, you know, it's not really going to be competitively useful. It's stale at that point. And so there's no real risk of unfairness in the competition. Next slide, please. Finally, we have unfair competitive advantage, which is the GAO's term of art for what can happen if you hire a former government official and that person has information in their possession, which is non-public and could be competitively useful in a competition. So there are a whole bunch of rules surrounding the hiring of former government officials. There are ethics rules. There are actually criminal rules in Title 18 of the U.S. Code and the post-employment rule restrictions. The GAO has said that's really for other agencies and for the DOJ to deal with, not us. But we will consider if a former government official created what amounts to an unequal access to information OCI. And in fact, the GAO has said that these situations where you have a former official that you've hired from the government and they might have information that could benefit the new company who just hired them, that situation is virtually indistinguishable from every other unequal access OCI out there. And the GAO assesses it the exact same way. There's really just one difference, and that is whether or not an agency can waive it. And we'll get to waiver later on in the presentation, but basically all the other OCIs that I just discussed, they are part of FAR subpart 9.5. And that part of the FAR says an agency can waive an OCI, but an unfair competitive advantage, the guiding principles come from FAR subpart 3.1. And that's really the part of the FAR that just says the government has to ensure that the competition is fair. And that's where the GAO gets its rule against these unfair competitive advantage situations from. But that part of the FAR does not include a waiver provision. So if there is an unfair competitive advantage from hiring a former government official, the agency can't waive it. So it's either going to have to be mitigated or it's going to have to be dealt with in a different way, including eliminating someone from the competition. With that, you can move to the next slide.
Yeah, before we move into Lindsay's section, I wanted to let everybody know that the CLE code word for today is OCI 2021. And with that, I will turn it over to Lindsay.
Great, thank you, Paul. So a personal conflict of interest is a situation where you have a covered employee that has a financial interest, a personal activity, or a relationship that could impair that employee's ability to act impartially and in the best interest of the government. The regulations clarify that a de minimis interest that wouldn't impair the employee's ability to act impartially or to act in the best interest of the government is not included under this definition as a PCI. Also, this definition only applies to a covered employee, which means a person who performs an acquisition function that's closely associated with an inherently governmental function. And that would be supporting, providing advice, or providing recommendations with regard to 8 specific enumerated activities of the federal agency. And these could be planning acquisitions, developing statements of work, evaluating contract proposals, and administering contracts. So here we have some situations that can create PCIs. The first of which would be the covered employee's financial interests that impair that employee's ability to act impartially. So this could include compensation, consulting relationships, stock or bond ownership, business ownership and investment interests. It would also include other sorts of employment or financial relationships, which could be seeking or negotiating for prospective employment or business, as well as gifts such as travel.
Thanks, Lindsay. Chris, we'll go back to turn it back over to you to talk about strategies for avoiding neutralization and mitigation of potential bid protest issues. The one thing I did want to bring up on personal conflicts of interest is that, you know, the relationship with many contractor employees and government personnel, I mean, it can be very closely related. People carpool together, people, you know, go out and have drinks, they go out and socialize. And, you know, sometimes those can go too far where they could give rise to a personal conflict of interest, or at least the appearance of one. But the issue you have to be aware of is that a lot of times that behavior is cutting both ways, that the same person that is drinking or riding in a van pool with your competitor's employees also sometimes riding with your employees. So before you raise those issues, and the government does take them seriously when they're brought up in a protest, you really do need to ensure you do your due diligence to make sure you don't have a glass house problem where you are criticizing your competitor for conduct that your employees are actually engaging in as well. So, sorry, Chris, I'll turn it back over to you on strategies for avoidance, neutralization, and mitigation.
Thanks, Paul. So moving into, you know, what do we do about OCIs and personal conflicts? How do we make sure that they don't happen in the first place? Or when they do, how do we neutralize or mitigate them? So the primary way that people use is an OCI mitigation plan. The first thing to know about these plans is that the GAO generally gives them a lot of deference if the agency has reasonably investigated the plan and it's tailored to the potential OCI. So that's sort of what makes them a very common and good tool in the arsenal to protect your award from an allegation of an OCI. And we'll get to that in a little bit. These plans should be detailed. You know, the more pages, the better in some ways, because you really do want to show that you've thought through all the possibilities and you have a lot of strategies in place, both in writing and otherwise, that are going to help avoid OCIs or mitigate them when they arise. And then ideally, you want to establish the plan prior to the OCI arising. That's not always possible. Sometimes an OCI crops up and it slipped through the cracks and you didn't realize it and you have to scramble. And that can usually be done as long as you react quickly. But in an ideal world, the plan is done before the OCI even arises. One other thing to keep in mind for these OCI plans is to make sure that they're consistent with your technical proposal. And the GAO has actually said that agencies should consider the effect of an OCI plan on a technical proposal, because sometimes they're not consistent and it can reduce your technical rating. An example might be if you think that you're going to have a subcontractor in your technical proposal who's going to do 45% of the work, but then you had them walled off from a bunch of things as part of your OCI mitigation plan, so that it looks like they're going to be doing more like 20% of the work. You have a material inconsistency there, and it could result in the government downgrading your technical proposal. So just make sure that that's something you check before you submit your proposal. Next slide, please. OCI mitigation plans should also provide procedures for early identification of potential OCIs, and then they should state when and how the avoidance or mitigation will occur. You should keep the plan and any related documents, and we'll talk about what those documents can be in appropriate records. And there's a reason why you want to keep these things in records for later. One is that solicitations frequently request such documents. So it's not uncommon for the government to say in a solicitation, If you have any reason to think that you might have an OCI, submit a plan as part of your proposal. Second, even if the government does not solicit an OCI mitigation plan or solicit an OCI mitigation plan, having the plan on hand can help demonstrate to the agency that there's no OCI concern if an allegation does arise, either if it's because you self-disclose one to the government or because a competitor raises it in a bid protest. Having the plan on hand to give to the government quickly will help provide confidence and assurance that you're on top of it. Finally, these plans are often critical to maintaining your award if there is a bid protest. So not only will it provide the agency peace of mind and a reason to say that you can still receive award notwithstanding a potential OCI, but it can also help if there ever is a protest and the GAO reviews everything. And so the agency will likely have to produce not just its assessment of the OCI, but the mitigation plan that it considered during its evaluation. And so again, having that plan and making sure that it's airtight such that it will withstand the scrutiny of the agency, of a competitor's counsel in a bid protest, and ultimately the GAO or the Court of Federal Claims is really key. Next slide, please. So let's talk about firewalls. This is one of the most common strategies that you'll see as part of an OCI mitigation plan. The goal is to limit not just receipt of, but also access to non-public competitively useful information by employees who really shouldn't have it because they're involved in a capture effort. As you can guess, based on the use of the terms non-public competitively useful information, firewalls are mostly about mitigating unequal access to information OCIs, but there are some very limited scenarios where a firewall can be helpful outside of that too, which we'll discuss in a minute. So a firewall should be specific to the contracts to which it applies. So you want to make sure that you state the number and the agency for both the contract on one side of the firewall and then the procurement on the other side of the firewall. Similarly, you want to list the individuals by name and title and really by organization too, if your plan is covering teaming partners or subcontractors. The firewall should also state what information is at issue, where it came from, what the type of information is. You don't have to go into too much detail. You don't have to put the information into the plan, but you should generally refer to it. And then you should also include the period of time during which the firewall is going to be in effect, both when it starts and when it ends. And typically, you're going to want that end date to go all the way through either the cancellation of the procurement or award and the expiration of any bid protest or bid protest filing period, in case nobody does file one. A firewall can be built around and include a lot of different elements and documents. It can be policy statements. It can include electronic access restrictions. So I know people will use ShareFile or other programs or SharePoint to restrict access to data within their system so that it makes it hard for people to access things when they shouldn't, using things like logins, passwords, credentialing, verification. Usually, though, what will certainly be included is a non-disclosure agreement. And really the best way to do this is to have people on both sides of the firewall sign a document. And on one side of the firewall, you'll have someone who has the information that they're not supposed to share because they were performing on a contract. You'll have that person say, I have not disclosed this to people on the capture team, and I'm not going to. And then on the other side, you'll have the people on the capture team also sign something saying, I'm aware that this person or these people have this information, and I can't ask them for it, and I have not received it from them, and I will not access it. And to the extent that you have a separate OCI mitigation plan, you can attach these NDAs, these firewall agreements, to that plan. You can also attach things like signed employee receipts of notices. So you can have employees sign a document saying that they've received a copy of the plan, or you can just put that into their agreement if they're going to be signing an NDA. You can also ensure that agreement includes representations of what measures have already been taken to ensure that there have not been any inappropriate disclosures of information. And then you'll generally want to include in the plan and sometimes in the agreements too, a reporting mechanism. So if there are any violations of the firewall, there's somebody to report to, a designated person or office. And you can include possible employment consequences for those violations, or at least put people on notice that there might be consequences. You know, my clients don't always do that, but it can be a way to provide even more, you know, assurance to the government that this is a very serious matter and the company takes it seriously. Finally, you can also try to maintain documents that show that whatever restrictions you had on access were effective. So oftentimes that will be through software that keeps track of who logged into which folders at which time, so that you can, if needed, go back and determine, okay, we realized that this information should not have been put in this folder. It was, who actually accessed it? And so, you know, having those sorts of capabilities can help you to prove after the fact that, you know, your systems did work and there was not any access that shouldn't have happened. Next slide, please. So let's talk about where firewalls work and where they don't. They are effective for unequal access to information OCIs, and that's primarily where they are used. They can be effective in very limited circumstances for impaired objectivity OCIs. And by very limited, I mean only when you're firewalling off a subcontractor, so that they're not, you know, you're preventing the awardee, the subcontractor, from evaluating the awardee prime contractor's work, or competitors' work, or work of any affiliates. That the GAO has said that can be an effective way to mitigate impaired objectivity OCIs. Now, bear in mind that there can be downsides to doing that. The biggest risk is that you might get a lower evaluation score if that subcontractor that you firewalled off won't be performing as much work as you initially thought. And that can come across in a lot of different ways in the evaluation, ranging from technical to corporate experience or past performance. The government might say, you know, these people aren't going to be that involved. I don't, you know, based on the mitigation plan. So I don't see their role as being as important in the evaluation. So you might lose the benefit. Firewalls are not effective mitigation for biased ground rules OCIs or for impaired objectivity OCIs involving the prime contractor's employees. So really, it's unequal access to information that we're concerned about. Next slide, please. So on this slide, we have a few other strategies that you can try. Firewalling is definitely the best one for unequal access. There are other things that people try and they can help, but in general, your rule of thumb for these items is that any one of them acting alone is not going to be sufficient in most cases. So you can try spinning off into new entities and creating another entity. But the problem with doing that is that OCIs usually carry across the parent subsidiary divide. So even if you do spin off a business unit or segment into a subsidiary, that can help a little bit, but on its own, that's not going to get rid of an OCI. But, you know, certainly to the extent that there are different business units, you know, I would mention that in an OCI mitigation plan, because it does provide some additional assurance that information may not be shared when it shouldn't be. Government authority over final decisions. I mentioned this a little bit earlier. The GAO has permitted this as one factor in approving a mitigation plan, but impaired objectivity OCIs can still exist even where the government retains final decision-making authority. So that's why I said earlier, it's important that you also not have a big level of discretion either. You can also have an alternative solution proposal. And the idea here is that, you know, there's a concern that there's an impaired objectivity OCI because you'll be recommending your own products or services to the government. Well, why don't we just also recommend other alternatives for the government to consider from our competitors? I don't think it hurts to do that, but on its own, again, it's not going to be sufficient because ultimately you're still presenting your own stuff to the government and your competitors' stuff as well. Finally, there are alternative contracting vehicles. I've seen agencies sometimes rely on the availability of other vehicles or the fact that the work is under optional CLINs to justify the determinations. The strategy, again, is unlikely to work on its own, though. Next slide, please.
All right, Lindsay, why don't you tell us about PCI prevention?
Sure. So when it comes to PCI prevention, the FAR actually provides some specific guidance, and it requires contractors to both identify and prevent PCIs, as well as prohibiting covered employees who have access to non-public information by reason of their performance on a government contract from using that information for personal gain. And to do this, contractors are required to have procedures in place in order to screen covered employees for potential PCIs, including maintaining and obtaining an updated disclosure of interest form. It also requires contractors to prohibit covered employees from performing tasks that create a PCI, prohibiting the use of non-public information from government contracts for personal gain, including through use of non-disclosure agreements, as well as reporting to the contracting officer any personal conflict of interest violation as soon as it's identified.
Thank you, Lindsay. All right, so the next thing we're going to talk about are bid protests, because this is also a fairly common area that arises in the context of bid protests. It ebbs and flows periodically. It was a very hot area probably 7 or 8 years ago. The issue still comes up, but it is not as frequent as I think people have figured out how to address the issue and how to avoid it, or you've had a lot of companies that have spun off subsidiaries that were creating conflicts of interest. So I think that some of this has died down. At the GAO, the general rule is that a protester's allegation that another firm has a conflict of interest is generally premature when filed before an award has been made. And that's the rule. The GAO typically follows that, but there are instances where if you wait until the award has occurred, you could be untimely. And the 5th bullet addresses this, where the agency specifically advises a protester before award that it considers the firm with the alleged conflict to be eligible for award, then you're on the 10-day clock to file a protest. Now, where this typically arises and where we've seen it arise is that there are times when your competitors will file a letter of concern with the contracting officer that you have a potential conflict of interest that should preclude you from bidding for a specific opportunity. The contracting officer may review it internally. What frequently happens is the contracting officer will send you a letter, say that there have been allegations by competitors that you have an unmitigated OCI. Please tell us about it. And if the contracting officer asks you to do that and you respond, and the contracting officer accepts your response and finds that you're still eligible for award, at that point, to the extent that the complaining party has knowledge of that, they're going to have to go ahead and file a protest at that point. But as a general matter, it's typically after the contract's been awarded. Now, the interesting thing is that there are cases from the Court of Federal Claims that would require a company to raise an OCI issue prior to the submission of the proposals. That if you wait until after the contract's awarded, it will be deemed untimely. And the standard that they sort of have applied is that both the public documents and the company's interest in the procurement were easily recognizable or obvious facts that make them subject to the blue and gold patent ambiguity test. Therefore, the contractor failed to timely raise its OCI claims prior to the award of the contract, despite the opportunity to do so and its easy access to the knowledge upon which it now relies. So if there are issues that you allege give rise to an OCI issue that you could have known, you did know before the contract was awarded, and then you wait to file it until after the contract's awarded, there's a chance your OCI allegation is going to be untimely at the Court of Federal Claims, that it should have been filed before proposals were submitted. So, I mean, the one issue that's sort of interesting is that you could have a situation where you go to the GAO, file a protest that has an OCI basis, and the GAO deems it timely, only to find it that it's been deemed untimely at the Court of Federal Claims. So the one thing that's important to remember is that the identification of conflicts of interest is a very fact-specific inquiry, and Chris mentioned this early on. And the other important issue is that there's a lot of discretion involved, and typically the GAO is not going to replace the agency's assessment with its own. It's going to look to see whether it acted reasonably in accordance with the applicable procurement law and regulation. The other thing is that, you know, as a protester, you're going to have to show hard facts. And this is something else that Chris mentioned as well. So to the extent that you believe there's an OCI ground and you're working with outside counsel to put that together, the more facts you have, the better. If you can identify a specific contract, specific individuals, what's being done under the contract that would give rise to an OCI, or what specific individuals are doing, you'll want to assist your outside counsel with developing a declaration. I mean, that's what's going to carry the day on these types of allegation. You know, the bullets also make the point that the GAO is only reviewing this for reasonableness. You know, has the agency acted reasonably? And it's just a really very, very tough standard to meet. You know, and you also have the case here from the Fed Circuit that discusses the considerable discretion that the contracting officer of the agency has. I mean, it's certainly a winnable argument, but given the level of deference, it always makes it very difficult, especially if you have the appropriate documentation and things of that sort. With regard to PCIs, you know, the GAO does apply the hard fact standards to PCIs as well. You know, they're going to focus on whether the individuals involved had exerted improper influence in the procurement on behalf of the awardee or against the protester. Again, they're going to look at the reasonableness of the PCI determination. You know, and has the government given the allegations meaningful consideration? And then if they deem that the government's actions were reasonable, they're going to deny the protest. So it's, you know, again, these are some difficult standards to overcome. All right. Now, the next thing we just wanted to touch on briefly was the agency's waiver of OCIs. And Chris had mentioned this previously in his portion of the discussion. So agencies under FAR Part 9503 have the ability to waive any general rule procedure of Subpart 95, which would include OCIs. I can't tell you that this happens very frequently, and the willingness of a particular agency to do it is very agency specific. And even within a particular agency like Department of the Army or Department of Navy, you know, it can vary between the various commands that you're dealing with. So, you know, this is also another area where it's good to have outside counsel involved, because they do have the ability to come in and try to prevail upon agency counsel to seek a waiver. Now, to the extent a waiver is given and you want to protest that, you know, it's the GAO's review is very limited, and They're going to look at whether the waiver complies with the requirements of the FAR, whether it's in writing, the extent of the conflict, and whether it's approved by the individual. So they really are looking at sort of the process and not the substance. They're not going to second guess the agency on whether an OCI should be waived or not. You know, and it also doesn't matter whether the underlying OCI investigation was reasonable. And it doesn't matter when it occurs. You know, the GAO's review of this is going to just be very, very, very limited. We just move on quickly to PCIs. The difference between the PCIs and the OCIs is that this is only going to occur in exceptional circumstances that this waiver is going to occur. So I mean, it's rarely used. I can't think of a single situation where I've seen it, but you know, we just wanted to put this in here so you know that it is available, and it's certainly another thing that you know your counsel can try to work with the agency to try to achieve. I think we're going to move to questions next, but I think a couple things that we touched on earlier that you know you may want to think about is that you know with regard to the OCI plans, the government does take those very seriously to the extent that an OCI issue arises and you tell the government that you had an informal plan or an OCI understanding or something like that, it's not going to carry any weight with the government. You know, I mean, the government may tolerate some delay in establishing an OCI program, but to the extent that it is delayed, you're going to have some explanation as to why it took you some period of time to get the mitigation plan up and running. The other thing you need to think about too is that if you are a small business, medium-sized business, larger business, it really doesn't matter. But you can hire former government employees that may have done some specific work for an agency that you do work for that had access to information that could be competitively useful from your competitors that you need to put a mitigation plan around. And so, you know, as you're interviewing people and thinking through what roles they have, you're going to want to get some insight into what information they had access to. Did they have access to competitors' information? Did they go to competitors' facilities to see how competitors were producing a product that you both may be competing for? And then to the extent that you identify issues, you're going to have to address it. The other thing too is that, you know, as you're hiring people, you know, get some sort of certification or something that, you know, they're not aware of any conflict of interest information. I mean, it's always good to have the file papered, but, you know, you do have to do some level of due diligence to, you know, address any of these concerns given the impact that they can have on your company. So I'll throw it open to the other panelists. I don't know, Chris, if you had any other additional thoughts, see if we get any other questions coming in, or Taylor, or
Hey, Paul, this is Chris. I did have a couple other things. One was in terms of the OCI mitigation plans. I think the points you raised are really solid, and they sort of highlight the wisdom of having both a general OCI plan that sort of guides the company overall for all of its government business that is always in action, and then for particular procurements, as situations arise, having a separate plan that's tailored to that specific procurement and specific OCIs that you anticipate arising. And so that way you're both covered in that you have something that's always ongoing and helping you during the hiring process for your overall corporate needs, but you also have something that's more tailored to specific procurements when a contracting officer may have a question down the line. And then the second thing was I wanted to kind of note the relationship between OCI mitigation plans and waiver of OCIs. Paul Paul's definitely right that it can be difficult, but also very worthwhile to talk to an agency about whether it would consider waiving an OCI. But I wouldn't start that conversation unless you're pretty confident about where you're standing in relationship to that OCI. And so you would want to make sure that, you don't think it's a significant OCI, so it doesn't require mitigation, ideally, under the FAR. Only significant OCIs require that. So that's your ideal thing, number one. Ideal thing number two is that even if it is significant, you have a mitigation plan that you think mitigates it. And then ideal thing number three is even if it doesn't mitigate it and the agency should waive it, you have a good reason for why the agency should waive it. And usually the best reason is going to be that the agency wants the benefit of open competition and the benefit of considering and potentially awarding the contract to you as a great company who's providing much needed services. So, again, having that sort of OCI process and plan in place early can make it much more effective later when there is an OCI and somebody thinks it can't be mitigated and you're seeking waiver, or even during a bid protest where you're pretty confident that, it's been mitigated and, it shouldn't be questioned, but nonetheless, if the agency is willing to waive it, you can waive it, and the protest ground is effectively going to be dead in most cases, as long as the agency follows the FAR, at least at the GAO.
I mean, Chris, I think you make a good point in that, the OCI document should be a living document. It's just not something you create and then put on the shelf. I think it's also important to remember that it should be part of, any orientation and part of and most of the codes of conduct I've seen, that our clients have, they do require their employees to bring these matters to the appropriate person's attention, both personal conflicts of interest and organizational conflicts of interest. Certainly it's something that, you want to include in your subcontract terms that you have with your subcontractors, that, they certify they're not aware of any OCI, or that if they are aware of an OCI, that they've brought it to your attention so that you can factor it into your pursuit. Because there are companies that lose contracts because of a potential conflict of interest that arises because of a relationship that the subcontractor has. So you want to get in front of those issues early in the process as well, as part of the teaming process, and certainly impose that continuing obligation in the context of any of your subcontract agreements that you have with your various subcontractors. So I think with that, we don't have any additional questions to address. We got done a little bit early, 5 minutes early. We certainly appreciate everybody that participated in the webinar today, and I want to thank Taylor and Chris and Lindsay for their excellent work on this presentation. We'll be restarting in September with a 4-part series on small business issues. Certainly, we thank you for being here today, and we hope that you all have a very healthy and safe summer. Be well.